Okay, for a little bit of taste of Texas A&M here in Washington, I'm going to say howdy. Okay, good. That was pretty good, actually. So this is a Texas A&M custom. I think classes. I mean, you begin your classes this way. The meetings, so on and so forth. We began with howdy, and then folks respond with howdy. Recently we had a new faculty member. It was a visiting faculty member came, and they had their first class. And they began the class and said, "Hi, I'm X," and they started talking. And they said they noticed that it seemed a little odd in the classroom. People were not they were only half paying attention and looking at each other. And finally a student 5 minutes in raised a hand and goes, "I'm sorry, Professor, has class started?" And he said, "What? Yeah, of course." He goes, "Well, you didn't say howdy, so we didn't know." So anyway, I want to make sure, at least for the Aggies in the crowd, you know that we've started now officially. So my name is Bobby Oddie. I'm honored to be the Dean of Texas A&M Law School, and have been in that post now for 7 years, or now 7 years as of this past summer. Texas A&M has been in the news recently for lots of things, not all positive. But the story of the law school really over this last decade or so has really been a pretty striking, as some of you know, a pretty striking tale, we'll call it. From unranked to the top 25 law schools in the country. From struggling on the employment front to the highest employment rate of any law school in the country, highest incoming GPA of any law school in the country, so on and so forth. But central to that success in many ways has been the fundamental aspiration of, and I'll say the university as a whole, and by extension the law school, to shape the dialogue for the law school about law, legal policy, politics, law and politics, and so on and so forth. We take seriously, is the way I was put, we take seriously the land grant mission of the university to make the lives of every Texan and every American better every day. This series that my colleague Milan Markovic, who will come up to the podium in a moment, really has put together reflects that. It's a time of obviously incredible change in our country and really the world as a whole. The legal profession, the law, the judiciary are not legal practice, are not insulated from that. That change has come to us as well. We are seeing it in terms more obvious ways like AI, other aspects of technology, ownership structures in the legal profession, and where those are going, changes in legal ethics, norms, and expectations. So an incredible amount of change and flux. This series, Law 2050, aspires to sort of spark a dialogue well beyond A&M and well beyond these 5 conversations in San Francisco, New York, Washington, Chicago, and Houston, to spark a broader national conversation that involves being intentional as a profession for the bench and the bar to think about where we are going as a profession. Rather than being objects of the changes that are coming to the law and legal practice, we want to be subjects of it. We want to define where we are going. We are not, if we're being honest, currently doing that. We are much more susceptible to the winds and the waves that come than we ought to be. This dialogue will hopefully help to spark that. We have 2 more sessions coming after today in Chicago and Houston, and then our goal is to kind of compile these together into a website and a communications plan that really kind of carries it well beyond the folks who've attended lunches or attended events or even read about it to kind of encourage this conversation. So anyway, we're excited about today's conversation. I was once upon a time a administrative law lawyer, maybe a bit of a scholar, although Carrie may disagree, back in the day, and so I'm excited to hear about it. It really is, as I was sharing a moment ago with a couple of folks, the administrative state, for all of the dialogue and discourse happening around it, will persist, will continue to play a central role in our systems. And so figuring out how it is going to evolve in the next few years and the next decade will be critically important. And we have an incredible group prepared to comment on that. So let me invite my colleague Milan Markovic, again, our host really, and organizer of all this, to get us started. Thank you all for being here.
Thank you, Bobby, for the very generous introduction. Usually he just calls me his Canadian friend because I'm originally from Canada. I was fortunate to pursue my studies here and teach at A&M. Obviously, A&M is a great institution, and the law school is doing amazing things, as Bobby said. And one of the real delights of an institution like A&M Law is you have great colleagues. So when Bobby tasked me to plan this whole series, we came up with this idea of Law 2050. What is law going to look like in 2050, and what does that mean? Technology is obviously a huge part of that. But one problem is I know absolutely nothing about administrative law. But I realize we need to think a little bit about what lawmaking and rulemaking look like in 2050. Historically, lawmaking and rulemaking have been very time intensive. We've really made laws and regulations the same way for much of the 20th and 21st centuries. And technology has the potential to disrupt that, make law and rulemaking much more dynamic. And I'll leave that to the experts. And I owe a great debt of gratitude to my colleague Dan Walters, who really took the lead on this panel. And I'll introduce our speakers in a moment, but let me just conclude with a great remark by a famous philosopher. Given that we are in such distinguished setting with Nobel Prize winners, former presidents, having attended and been members of this club, the famous philosopher is Yogi Berra. And he has this great line, "It's tough to make predictions, especially about the future." And a famous physicist, Niels Bohr, actually made a very similar comment as well. So Yogi Berra, Niels Bohr, I feel that's very appropriate for this particular setting. And I look forward to a conversation about the future of rulemaking and lawmaking. So without further ado, let me just introduce our very distinguished speakers here. The Honorable Michelle Childs was appointed to the United States Court of Appeals for the District of Columbia Circuit in July 2022. She was previously on the United States District Court for the District of South Carolina. She holds a number of degrees, including from the University of South Florida Honors College, the University of South Carolina School of Law, a master's in personnel and employment relations, also from the University of South Carolina, the Darla Moore School of Business, a master's of judicial studies from Duke University School of Law, and an honorary doctorate degree in public service from the University of South Carolina. So thank you, Judge, for joining us. Professor Carrie Colonese is the Edward B. Shills Professor of Law and Professor of Political Science at the University of Pennsylvania Carey School of Law. He is the Director of Penn Law School's Program on Regulation, and he has written quite a bit, over 300 articles, book chapters, reports, and essays related to administrative lawmaking and rulemaking. Carrie is also a senior fellow of the Administrative Conference of the United States that meets here in DC, and he's also a member of the American Law Institute. And thank you, Professor, for joining us. And last, but certainly not least, we have my amazing colleague, Dan Walters, who has, well, perhaps his greatest accomplishment is putting up with me and Bobby. But in addition to that, he joined us. He recently gained tenure, so congratulations, Dan. And he joined us from Penn State Law School. Before that, he was a regulation fellow at the University of Pennsylvania Carey School of Law. Dan's focus is administrative law and regulatory law, very much consistent with today's panel. And his scholarship has been published in many leading law reviews, including Yale, Stanford, and Michigan law reviews. So without further ado, I will now leave it to Dan to start this fascinating conversation, and then we'll hopefully have some time for your questions. Thank you.
Great. Well, thank you, Milan, for that introduction. And I have to say it was a bold move or a risky move asking me to moderate this conversation, given that I'm sort of a technophobe or a Luddite in many ways. But I am an administrative law scholar, and I have been thinking about how we adapt the field to all of the innovation that we're seeing. So I'm really excited about this conversation to learn from real experts who are maybe not so technophobic as I am today. So we want to get right to it because we have a lot of great questions to talk about today, and we also want to reserve some time to hear from you. So do think about your questions. We'll have about 15 to 20 minutes at the end of the conversation for that. But without further ado, we'll jump right into it. And I thought a good way to start this conversation would actually be to sort of do some table setting by just taking stock of what is happening right now that you're seeing in the world today in terms of innovation. So in what ways do you see technology disrupting legal practice and the process of making, interpreting, and implementing law today? And we'll start with Judge Childs.
Okay, and thank you for the opportunity to be here with you. It's always fun to be in the room with a lot of experts, but as well as novices. It gives me the opportunity to also learn from you so that I don't have unintended consequences of our decisions. So I'd like to be part of this conversation. I did hear both of them having a UPenn connection, so I wanted to join in on that. I have a UPenn law grad who's clerking for me right now. Yes. But I would just say that at this point in time, the law has to catch up with technology. I mean, technology is going to the speed of light, and we know that law is a lot more deliberative. It's slow. There's human element for the decision making and judgments, and we want that. We want that critical thinking to stay a part of the process. But the law has to catch up. Technology helps us in the sense that it brings us forward to whatever the new information is, to whatever the new trends are. And then we have to complement it with the human decision-making element. Some of the issues that become more difficult with that respect are jurisdictional, quite frankly, too, because wherever that technology is coming from, it could be something with respect to personal jurisdiction, in terms of how we would judge that. We also have the big issue of social media. We're getting a lot of our information from social media. We're getting a lot of our misinformation from social media because it gets abused in that regard. AI is a wonderful tool, but they can also have regrets in the sense that it is such a great tool that we're not sure what's genuine, what's authentic. The rules of federal procedure so far have been able to assist us with court with respect to any evidentiary issues, and we're okay with that, with respect to using authentication and things of that nature with respect to allowing the particular tools to come into the court. But we, have these issues with respect to AI in terms of how it can be misinformed or how it can be utilized such that people don't know what is really authentic. And then, of course, there's the court of public opinion that can be a disruptor with respect to how law is shaping itself, because if people are getting their information from social media or just have a preference for what they want in terms of law and things of that nature, then that can be a situation as well. But AI is good in the sense that it's very efficient. It allows more access. It allows more efficiency in that regard to court and technology. And so it is something, again, that we all need to think about. How do we complement each other from the human element and AI?
Great, and we'll go over to Professor Colanesi now for some opening remarks on this question as well. I'm probably going to slip and call you Kerry, by the way, I should say.
Fine, that's fine.
He was a dear mentor to me, but Professor Colanesi.
Let me start by saying howdy. Should I say howdy y'all too, by the way? I don't know if that's, and I also
It's
wanted
encouraged.
to note that the moderator who claims to be not up on technology is the only one of us on this panel who's looking at his notes on an iPad. So there's something about a generational thing here that maybe is worth bringing into the conversation at some point in time. Let me just start by saying, by way of level setting, that a conversation about technology and how it might be disrupting lawmaking, rulemaking, is actually a big and amorphous kind of conversation, in part because what technology is we're talking about could vary. Some of these things can be related, but not necessarily all of them share the same properties or the same problems or the same possibilities. And we could talk about just the internet itself. I was involved back in the turn of the century now, literally, around the year 2000, when the federal government was thinking about using the internet to make documents related to the rulemaking process more accessible to the public. Yeah. When I was in law school, you could find out about regulations by going to a repository library and pulling out a hard copy of the Federal Register. And you would have to do that during the hours of that library. If you wanted to find documents in the record, an agency's rulemaking record, you'd have to come to Washington, D.C. and go to a docket room. Again, during particular business hours, you'd have to give a clerk a request slip for a particular file. They'd come to you with the hard copy. If you were lucky and you wanted to make a copy, if you were lucky, the copy machine would actually work. If not, you might be out of luck. You didn't have a smartphone that could take a picture of anything. That all changed with the advent of the internet. And now, my law students can look up any Federal Register document at any time, in their pajamas at 1 in the morning. They can go into the agency's background dockets, again, and extract materials at any time remotely. It's amazing, right? So that's one technology, just the internet itself. That's what I might call the technology is digitization. But then there's also, as Judge Childs mentioned, social media, there's blockchain, there's artificial intelligence, and lots of these things are moving fast and changing rapidly. And it's also important to note that it's not a technology that's singular. So artificial intelligence, we refer to it with this singular noun, artificial intelligence, but there's narrow artificial intelligence where there's machine learning algorithms that have been designed to serve particular functions and tasks. And then there's more general artificial intelligence that I think most of us maybe associate with artificial intelligence today, these large language models. But even those, there's several big popular models, ChatGPT, Claude, Gemini, Llama, and the properties of all of these algorithms or these large language models can vary, and their uses can vary too. Back in 2020, the Administrative Conference commissioned a report on how federal agencies were using artificial intelligence. And a team of researchers from Stanford and NYU worked to try to identify all the possible uses of AI across the whole federal government, at least those that were not classified. Obviously, we can't know a whole lot about the classified ones in the realm of security. And they canvassed over 140 different federal agencies, and they found 157 use cases in 2020. 150 different uses of artificial intelligence. Now, I've been working on a project and have a paper that's in the works with some of my students, and we have now found, as of the end of 2024, so just 4 years later, over 3,000 use cases. That's an indication of how this artificial intelligence is moving through the federal government. But again, it's not an it, but it's a they. It's a collection. Artificial intelligence is a plural, not a singular. Lots of different uses, lots of different designs of these algorithms. But let me just give you some samples to give you a sense of the range across which these 3,000 plus use cases can be deployed. One is in research. So just one example, the Department of Commerce is using a machine learning algorithm to predict markets that might be good candidates for US businesses to try to make some inroads. And that's just part of their research, and then they will use that to inform ways that they might work with businesses to open up new markets. And by the way, research is the biggest of all of these categories. It is by far the largest of all of the categories. The second category that I might mention is in enforcement, and this is a pretty big one too. It is a common challenge among regulators that there's far more regulated entities that might be out there not complying with the rules, needing some oversight, targeting by inspections or auditors, than an agency can ever really, with limited staff, deploy. So there needs to be some kind of strategic allocation of resources to oversee and assist with the enforcement process. So the Securities and Exchange Commission uses actually multiple different machine learning algorithms and models to try to help it use its limited auditing staff more effectively to try to identify securities fraud. Now, those tools are not themselves determinative, but they and nowhere have I found that agencies are using it in enforcement as a determinative tool, but it does help direct the limited enforcement resources toward some cases that are more likely to have violations than those that are less. A third category is in public engagement. And here's a nice example. The Department of Education has financial aid programs and information that they've needed to convey to the public. So they've created a chat bot that they call Aiden. I get it? If it's AID, Aiden. The Aiden chatbot has been deployed for helping applicants for college financial aid information. That's a kind of public engagement tool. And we see some of that going on across a range of agencies. A fourth category is in internal management. And there's lots of things here, from tools that can help triage internal IT staff to help different employees with their computer problems. But here's an example from the Department of Health and Human Services, which has developed its own internal AI tool to help process large volumes of documents and help manage those. And that's a common challenge that a lot of agencies have, is just managing the paperwork, and AI can help in sorting that. Fifth category, and this is rarely used, but it's probably the smallest category, is in assisting with adjudication. Not actually substituting for humans, but nevertheless assisting. The Social Security Administration has a tool that is called the anomalous I-claim predictive model, that helps it decide whether there are some claims for Social Security benefits that might need additional scrutiny by humans to oversee it. So there's lots of uses that are happening. These, by the way, are all uses that have been identified and reported by agencies themselves. Either we've scoured their online uses, they've reported things in AI inventories. It's probably still an undercount, and it doesn't even take into account, the individual employee that might go onto ChatGPT to help them do something during the day. I guess I'll conclude by saying that in the time since we stopped our inventory, we have a new administration, and its so-called Department of Governmental Efficiency, or DOGE, has released at least a PowerPoint presentation indicating that in the rulemaking context, they think that they can use AI to assist in a major deregulatory effort by identifying regulations that are not not required by statute and therefore may be candidates for elimination, as well as for sorting through public comments and assisting in the drafting of regulations as well. It remains to be seen exactly how that will roll out, but that is a disruption maybe in progress at this moment. So hope that's helpful as a table setting to our larger discussion.
Very helpful. And I want to come back and talk about that fifth category that you mentioned, sort of having your day in court a little bit later, and especially hear from Judge Childs about that very difficult question. But before we do that, I want to give the panelists an opportunity to maybe reflect on something else that Carrie sort of mentioned, which is this sort of exponential growth of the use cases of AI in government. I mean, that is, remarkable that you went from just a couple hundred to 3,000 use cases. It really begs the question, what about the next 25 years? Is that exponential growth curve going to continue? Is there room in the law for that kind of innovation to, keep disrupting so many things at that rate? So I want to invite you to reflect on what we can expect over the next 25 years, given that we've just seen an incredible amount of innovation just in a few short years, and we still have quite a ways to go.
Well, legal services have generally been the gatekeeping function of the lawyers and, the librarians. I'm thinking about some of the examples you gave, and it goes back as far as microfiche even.
Yeah.
But now this AI is helpful. Again, we have to look at, it's not going anywhere, so we have to look at how it'll be helpful. But think about some of the basic functions. If you have extensive documents, and I've done a lot of cases that deal with e-discovery, and there might be 1 million documents at stake, it's just not humanly possible to deal with all of that. So they have a term called TAR, Technology Assisted Review, where it's been proven that if you use that technology, it is better than the human element in terms of the accuracy. Of course, we want to have a way to check or verify or identify, any of these ways or processes. But think about some of the things where you can just go into your ChatGPT or Claude and just as a premise to start a conversation legally. You would still want to get true legal advice, but it makes it more efficient, it makes it more accessible for this big gap of legal services. It's much more affordable. That is a conversation starter to give somebody just a place to go, whether it's something as simple as landlord-tenant, or you just need a basic contract of some sort, a basic simple will, things of that nature. So we're there now, with respect to those types of things. And then, of course, Professor Carey mentioned things that are happening with agencies. There are certain areas of the law where I indicated before that the speed of AI is way ahead of us. But think about something like autonomous vehicles. You end up creating kind of a set of regulations or laws just to encapsulate, some particular trend that's going on because the legislation is not necessarily there or things haven't worked their way through the court system in that regard. So you have to think about those types of things. Think about cryptocurrency. I mean, that's on us now, but how do you deal with really keeping that genie in the bottle, so to speak? You can't, because AI, it's already here. People are utilizing it one way or the other. So it gives you just that opportunity for courts to move forward on that. And then as we're reshaping law and legislation, you still are going to need the lawyers. Again, I will say that the lawyers will have to become more technically literate. When we're in these e-discovery cases, judges are having to go with Federal Rule 1, which is the just, inexpensive determination of every action. So that means that we have to be efficient case managers. We have to be more technically literate. We have to understand the storage, the management systems or retrieval systems of the various corporations. And a lot of times that requires the experts to still come in and teach us that technology with respect to any type of cases that we'll have, because we're analyzing that data. And there's millions of dollars at stake in just these retrieval systems or how you're going to generate this information through the courts. But for the basic functions, for let's say you're at magistrate court and there are some form orders, it helps in that regard because it's just so much more efficient so that lawyers even, as well as judges, can spend their time on more of the complex issues rather than some of these routine matters that perhaps AI will be much more assistive for us.
So I guess just to intervene there for a second, what I kind of hear is that there's a lot of low-hanging fruit out there where the technology is already, in some sense,
Yes.
sort of fulfilling the role of a traditional human lawyer. But there's going to be some things that are just irreducibly complex that are going to require human judgment. And I'm wondering if either of you have any thoughts about the challenge of preventing the extension of some of these tools into more complex spaces where we need more human judgment before the tools are really ready for prime time. Carrie, you mentioned DOJ's efforts already, but I'm wondering if either of you want to reflect on that at all and the challenges that are inherent in policing that boundary as innovation accelerates very, very quickly.
Well, before you even get there, I would like to know, will we have AI charged with the unauthorized practice of law?
Well, I do think that in terms of combining the two questions about the speed of innovation and then how to manage it, just to give you an idea of the speed of innovation and in building on your comment about the unauthorized practice of law, the first manifestation or public release of ChatGPT was version 3.5. It was issued in November of 2022, and OpenAI had tested it on the Uniform Bar Exam, which is both an essay and a multiple choice exam. And it flunked. Performed at about the 10% level. No more than 6 months later, actually March of 2023, OpenAI released ChatGPT version 4.0, and it passed the Uniform Bar Exam at the 90th percentile level. Now, I find it humbling as a legal educator that we have our students in the classroom for 3 whole years, and then they spend 2 months usually in the summer with concentrated study to prepare for that bar exam. And here's this tool that came along and passed at the 90th percentile level. It came up to speed in just the 6 month time. Now, does that mean that ChatGPT could become a lawyer and substitute? No, there's lots of other things that are not covered by a bar exam that I think make for good lawyers and lawyering skills. But it does show you the speed at which this technology is moving forward. And then the question is, how do we integrate it into responsible uses that can lend value, whether it's through efficiency, whether it's through fairness. We don't have a perfect legal system right now. It may be that these algorithmic tools can, in some cases, get us to a fairer, more equitable system if they can be applying rules more evenly and even-handedly in a way that maybe even humans don't always perform that way. There's been studies of Social Security disability claims adjudications that show wide variations in judges. I think actually the study of judges in the Dallas office of the Social Security Administration going back some years ago, in which some administrative judges were granting benefit claims 90% of the time, and other judges in that same office were granting them closer to around only 10% of the time. And that suggests that probably humans are not, across a whole large system of the thousands of Social Security judges, for example, that there's some variation there and some unevenness, and maybe one single algorithmic tool, if it's well developed, well validated, deployed responsibly, and now these are all big ifs, and they're important ifs, But maybe that they can do better than the current system we have, even when it comes to things like consistency and fairness. But it's not, and if we're talking 25 years from now, is this conceivable? Yeah, absolutely. I think it is conceivable. It's conceivable to really be thinking about law in a different way. Let me give you an example of one regulation from the Code of Federal Regulations. It's actually Title 14, Section 121.383E. Now, you all know what this one is, right? This is a rule that prohibits a commercial airline pilot from having a license after they are 65 years or older. The law says no pilot may serve as a pilot in operations under this part of the code if that person has reached his or her 65th birthday. Now, we know and have long known that rules like that can be over or under inclusive. There are probably some people who shouldn't be airline pilots who are younger than 65. And then there's probably some people who would be very good pilots still, but are older than 65, right? And this is a very common phenomenon with regulating by rules. They're generalizations. What AI has the potential to do is to move beyond generalizations and make individualized predictions. What can we say about this person or that person or another person with respect to, say, their risk of having a heart attack if they're going to be a pilot, or their ability to fly a plane safely? AI tools in principle could allow us to start rewriting tools like this, redesigning them so that they're not just these clunky, if you will, bright line rules that can be over or under inclusive, but can actually make what Omri Ben Shahar in a book has called personalized law, where you can get actually, very individualized predictions. And that's possible, I think, in a lot of different areas. I think we're likely to see it. It has to be done well. We have to have good ability to define what the goals are. So, what exactly are the risks that we're worried about with pilots? That's important. We have to have good data. But if you can do that, then AI might actually, in some realms, really transform even what we think about as law. It might really no longer be these clunky kind of written down rules, but rather an AI predictive tool that you have to pass or not pass. That's going to raise all sorts of if we go down that road, all sorts of other questions, and maybe we want to talk about those as we continue the conversation. But yes, I think there's a lot more that could happen over the next 25 years.
So let's talk about some of those risks, because of course with the use of this technology to reduce error, to make more individualized predictions about behavior, et cetera, there is a risk of bias and inequality sneaking in. And I want to kind of think also generally about what administrative law has done as kind of a response to some of those risks in the past, and whether it's going to be sufficient in the future. So, transparency has been incredibly important in the development of administrative law and regulatory power. But a lot of these tools that we're talking about are somewhat inscrutable. So it's not possible to, really pull open the hood and see what's going on and understand what's driving the decision making in an individual case. So I'm wondering if you can reflect on that and how that should affect our thinking about the risks and benefits of these technological developments.
Well, one of the things too, to get back to just the speed of AI and why it's here to stay and why we do, need to confront it, think about the risks, but also embrace it. Frontier has a study, and it says that AI runs at an average speed of more than 1.1 quintillion calculations per second. And that is approximately 760 trillion gigabytes per day, according to ChatGPT, while the processing capacity of human brain is estimated to be 120 bits per second and can process only as much as 74 gigabytes of data a day. So we just need to understand that because of all of the resourceful information that we'll get from AI, again, we have to embrace it. Now, getting on to some thoughts about these algorithms, though, and we're talking about the human bias elements of it. The concern there in terms of the risk are this is built from human data. And if you go back to many areas of discrimination, such as employment, housing, healthcare, and there can be thoughts of others, if that's the data that you're extracting, then that's the problem with the algorithm. The same thing with crime. Are you more likely to commit the crime based on zip code? Think about education, things of that nature. So those are some of the concerns because there's still that human element that extracted the data in the first place that is now being asked to allow this to be the output later. So you have to put some contours in there, with respect to ethics, professionalism, making sure that the data itself is competent and have, some viewers who are looking onto that. So there has to be some level of review in that regard. It's going to reflect wonderful opportunities for good outcomes, wonderful opportunities for more efficiency in those outcomes. But again, there's still that problem with the bias and discrimination with respect to the data.
I concur and would stress that what's so valuable about what you just walked through for us, Judge, is that we need to think realistically about AI's strengths and weaknesses in comparison to the status quo. So it's not as if we have a system that is bias-free, and then we're going to now go to a system that has bias. In fact, as you said, a lot of the bias that comes out of AI tools emerges because the data, which were human-generated and produced, have bias built into them. I think it is a hopeful vision, though, that bias can be reduced with a greater reliance on digital algorithms relative to the ability to reduce implicit biases in human beings. That's hard to see. We've been working at that in various ways as a society, and we're going to keep working on it, but it's hard to eradicate biases from humans. It's more plausible to say that algorithm might be a path forward to reducing bias for, I think, two reasons. First of all, to use AI tools, well, you need data. And once you have the data, you can start to analyze the biases that exist. We don't often, with human distributed systems, collect the data. So there have been, I cited one study about the Social Security Administration and its adjudication that was done, but there's a lot of other agencies and organs of government where bias might be creeping in through human decision makers, but we just don't know about it. We don't have the data often. So if we're going to use AI tools, we're at least going to get those data where we can start to see and study and identify biases that exist. And then the second reason why AI may be a hopeful path forward for producing even a fairer governmental system is that in principle, one can adjust mathematically these algorithms so that if there is bias in the underlying data, that can be adjusted. And if we can identify it through the data analysis, then we can adjust it. So and in principle, again, it's these algorithms. They don't. There is a lot of concern about what's called the alignment problem, about them taking on sort of a path of their own, and that's an important thing to worry about. But particularly for some of the more narrow forms of AI, where we're not talking about generative, free-flowing models, but just well-constructed, tightly parameterized and validated models. There's a possibility that somebody who goes in and for a claim in one part of the country then will get the same thing with the same kind of outcome as they would get in another part of the country. So that seems to me to be a hopeful vision. It does mean it has to be used responsibly. It's not going to come about by just taking off the shelf some tool and then deploying it. We've seen examples where some of the big companies have released tools early on. Microsoft famously or infamously released a version of Bing that was spewing racist sentiments, and they quickly had to pull it back. So you have to be careful and cautious about how you develop these tools, but there's the prospect, I think, of being both more efficient and more equitable and fair in the future.
So I'm getting the signal that it's about time to hand over to questions from the audience. However, I want to ask one final question, and maybe we can get quick responses to it. And it goes kind of meta in a sense, and I don't mean meta in the sense of Facebook or whatever. I mean meta-analysis. So we already kind of talked about broad visions of change and the possibility that these technologies might make personalized law possible. But I'm wondering about another scenario where we sort of have some of these technologies begin to replace sovereign law made by governments, right? So the foundation of our law is that there's a monopoly on the legitimate lawmaking authority in state and federal governments. But could technological innovation, especially innovation that might allow private actors to compete with traditional governments for the production of better law, undermine that sovereignty over time? And what effects might that have were it to take hold?
Well, government is based off the consent of the governed, and so everybody wants to participate in the democratic process with respect to how these laws are going to be developed. Private actors, however, do have a space. When you think about ADR or some type of arbitration agreements, AI has created a system in certain industry where you can actually go to AI to assist you with resolving the dispute. And again, it's all about what information is uploaded, the opportunity to access it and, be complementary to human judgment if necessary for levels of appeal, depending on what you've agreed to with respect to any type of arbitration contract and things of that nature. If it's the final decision maker, or again, do you have any levels of appeal? But I do think that it's still separate. I mean, we will still have a parallel track with the governed, all of us voting, taking place, being part of that democratic process. But then what is it that we will separately contract out for our purposes of being more efficient in having access to the law?
I again would concur with that and recognize that both on the lawmaking side, we have had for many, many years a realm that sometimes lawyers call soft law, sometimes called voluntary standards, that are playing a really important role. I mean, the fact that your iPad there can talk with somebody else's phone here is not because of any governmental standards, but because of standards that have been set by these non-governmental bodies. In the adjudicatory function, it's not just formal kind of ADR type functions, but even informal dispute resolution tools are being deployed. eBay, for example, has a digital judge essentially that helps customers that have had some kind of bad experience with a transaction work that out. And in fact, eBay reports that customers that have used their online dispute resolution tool are more likely to come back and do business with eBay again than customers that didn't have a problem in the first place. How about that? You know, and just I think it was just yesterday, that very highly consequential realm called Major League Baseball is moving to next season robo umpires that will allow for players or to be able to appeal judgments of the human umpire on a limited basis. But you can begin to see that, you know, these tools are proliferating, and I think when they proliferate, in some ways they are performing functions that have long been performed by non-governmental entities. Like, we've never had governmental actors performing the role of umpires in baseball games. But there are also going to be, I think, more receptivity and maybe even more demand by the public that governments are using the best available tools as well. We've got to really worry about whether the government is going to be set up in a way that meets those demands. I have heard, you know, from folks who are in our, sometimes in a very long queue in adjudicatory processes, who say, you know, why can't this just be automated? And I think we'll start to see an expectation that these long backlogs of whether it's you know, government benefits cases or maybe even civil or criminal adjudications. Why can't this be speeded up? Why can't we do what eBay does? And so, you know, this is the vision for 2050. We may be there and seeing much more of this. Sovereignty will be, you know, as I think it has long been, still there, but, you know, existing alongside other aspects of society.
So I have failed in my fundamental duties as a moderator to know the time that we actually end. I thought we had until 1:30, but we only have about 5 more minutes, I guess. So I want to hand it over to the audience for questions. If you could just say your name and introduce yourself and pose your question.
I'm Ed Richards. I'd like to bring this back around to rulemaking. When the APA came up with rulemaking, it was a fast procedure. And in fact, rulemaking is slow, is ossified, because powerful groups disagree on the policy behind the rules. And we give them due process and we let them litigate this. I'm not sure where AI changes that dynamic. Maybe you can build the record a little bit faster, but the whole record process is just another sand in the gears that judges put onto rulemaking because powerful groups disagree about policy. So I'm not sure, maybe the panelists can speak to, if rulemaking's ossification is really driven because of powerful interests not agreeing on the rules, is there a shortcut in AI? Do we just do away with the due process and let the agency or the decision maker make the rule?
Take that one to start.
Well, I think it depends on whether you're a responsible administration or not. I'm going to assume we're talking about a responsible administrator who wants to do rulemaking in a careful, thoughtful way. And I would say that AI could be helpful for speeding up some tasks, like processing comments and doing underlying research, but it's not going to substitute for the kind of human relationship that we also know is important for regulators to establish. There's some very good research that shows that when regulated entities have an opportunity to be heard, when they've got notice and an opportunity to be heard, they're actually more likely to comply with rules. So if anybody's thinking about AI as a shortcut for that, and we do have a current administration that seems to think that they can actually short-circuit the notice and comment rulemaking process for a large number of rulemakings, you really can undermine, I think, the legitimacy and the trust that people might have in rules maybe it does take a while to develop them, but at least at the end of the day, we've had a pretty strong tradition of respect for complying with those rules, even if they're expensive. And regulators need to be aware that that is something not to be lost by relying on some short circuits through AI tools.
I would agree that certain small tasks like the document review for the comments, et cetera, but I think the bigger issue is the transparency, the due process and the notice and the opportunity to be heard publicly, and not just for the parties who are at stake in that particular litigation, but for the public to understand what's going on. We were talking earlier that one of the beauties of administrative law, and also one of the secrets of administrative law, is that the types of matters that we hear, they actually affect citizens all over, whether it's gas emission, clean water, et cetera, et cetera. But we seem to talk at a kind of higher esoteric level because that's the way it's litigated.
And I think, by the way, just to also amplify the transparency, I think, about the use of these tools is important. And to your point, Dan, about yes, there may be some degree of ultimate inscrutability, but two things. One is that's true of humans as well. And second, computer scientists are actually really making some advances, and this is an area of really active research to try to make these AI models more explainable and understandable.
I'm going to try to squeeze in one additional question here.
Dana Dyson, visiting professor of the practice at the Bush School, DC. But I practiced national security law for over 33 years. So I tend to view AI through the offensive and defensive national security lens. And during my practice, a big part of it was looking at technological operational capabilities and trying to figure how statutes and regulations that were written long before that capability came on the scene, right, applied. I wonder what you think and how you think the law needs to evolve with the innovation and the speed and the change that's going on right now to address the threat that AI poses in the sense of perhaps mandating data integrity, right? Mandating algorithmic integrity, or what you see about that particular topic.
I recently concluded a service as a chair of a National Academy of Sciences panel that was charged with looking forward to the next, not 25 years, but just the next decade for the U.S. Coast Guard, asking some of these very questions about whether, what kind of challenges the Coast Guard would face from technology was one of those areas, and then whether the Coast Guard would have the legal authorities to meet those challenges. And I think all national security entities would face that same kind of question. One of the key answers that we recommended is that at the same time that national security agencies engage in strategic foresight, and the Coast Guard has been a leader in this through something called the Evergreen process, where they are really looking forward to what are the new emerging security threats and other challenges in the maritime sector, that they also at the same time include lawyers in that strategic planning process, that they create what I call a legal foresight practice. And that is making sure that at the same time that they're starting to see things emerging, that they're looking back at their statutory authority and saying, do we have it or not? Now, I think in a lot of national security contexts, the laws are sufficiently general that they can accommodate a lot of risks and room for these entities to respond to new technologies. We are in a world in which deference to agencies may be changing after Loper-Bright and the overturning of Chevron. However, in the national security context, I mean, there are several papers even before Loper-Bright that said that, you know, there's probably a separate standard for deference in those contexts. And I would be willing to bet that even this Supreme Court would ultimately give the agencies more deference about some general statute applying to a new situation when it deals with a national security threat. But I do think that building in lawyers more into the forward-looking process. I mean, a lot of lawyers are looking backwards usually at precedent, but getting them to also be involved in the forward-looking process is really important.
We're going to squeeze in one final question.
Thank you so much. My name is Nikel Allen. I'm the Director of Open Government for the District of Columbia. And I do have a question for Judge Childs. What type of guardrails does the court need to set up for practitioners around AI to protect the public?
That's a great one. And as I think about it, the Thomson Reuters put out something, and they talked about how there's the 7 C's. Basically, you have to have competence, confidentiality, consent of your client, confirmation that you have to be the ability to use the AI, think about any conflicts that are within the AI, and then also candor with the court, and that's not happening in certain instances because lawyers are not checking their citations. We realize that AI has hallucinations. Some courts are responding with sanctions, you know, in that regard. And then, of course, compliance with any of the rules. Some courts are actually setting out these certification orders that you have to certify whether or not you've used AI, so I think that's a good check on that as well, so that we know ahead of time whether you've used it, and we may look at those papers a little more closely. But mostly, you just need to also get that consent from your client that you've even used it, and then the candor with the court.
All right, well, it has been a fantastic conversation listening to you two powerhouses talk about these really important issues. So I've really enjoyed it. I hope you've all really enjoyed it. And please join me in giving our panelists a round of applause.
Wonderful.
Great.
I want to invite everyone to join us outside for us coffee and dessert. But again, thank moderator, my colleague Dan Walters, as well as the panelists for a great discussion. I had 10 questions. I hope you give me at least one of them. So hopefully over coffee, I can get some of those answered as well. But thank you all for being here. We hope you've enjoyed the conversation. Again, we have 2 more coming. If you happen to be in Chicago or Houston at the right time, we'd love to have you there. But otherwise, again, we'll be sharing more word of this with all of you, and we hope you'll share it with others as well. Thank you for being here again, and thanks to our panelists. Thank you.